In a 6-3 ruling, the Supreme Court today rejected North Carolina Republican lawmakers' bid to grant more power to the state legislature. At issue, the state's congressional districts map, which heavily favored Republicans and was invalidated by the North Carolina Supreme Court. And while the focus was on gerrymandering, many were concerned a ruling in favor of those Republicans would have had a broad and dangerous consequence for presidential elections. Joining me now is Mark Elias. His firm represented the plaintiffs in this case. Mark, thanks for being here. Just explain briefly the merits of what we saw today.
This is a great case for democracy. The right wing had been peddling this theory called the independent state legislature theory that in a nutshell said that when state legislatures draw maps for federal races, congressional, or when they pass laws that govern federal elections, congressional, Senate, or presidential, that somehow they're immune from state judicial review. They don't have to pay attention to state constitutions, and the state judges can't review what they do. That got rejected soundly today, 6-3. And so that's a very good day for democracy.
So come 2024, there was building concern that a state legislature, if this was proven, if this was upheld by the Supreme Court, that a state legislature could say, actually, we don't like the results of this election. We're going to put these results in instead, and we have all the power. Did I get that right?
You did. Look, this is the John Eastman theory, right? The independent state legislature doctrine doesn't exist without John Eastman and vice versa. And I'll tell you, as the lawyer who led, more than 60 victories for Joe Biden and the Democratic Party against Donald Trump after 2020, this is a big relief. We were fighting those cases one by one. We had these theories come up. We were able to bat them back. But once and for all, to have the U.S. Supreme Court put this to rest so we don't have to worry about it in the future is a real advantage.
So when the court said, hey, listen, no, you can't overturn the results of the election, there was no fraud, or you can't just submit new electors because you don't like the electors that were originally chosen, this is the Supreme Court saying that that's what the state court's role is. They have the authority to do that.
Absolutely. So they said basically, I think, one thing directly, one thing indirectly. The first is that where a state court says this is what the law is in our state or what our state constitution requires, that's the end of the road. So that's the first thing. The second is by inference, and I think a pretty strong inference, it also says that the state legislatures are not these omnipotent entities, and they can't decide to disregard election results because they don't like them and come up with new ones. And of course, that's what we faced when Texas tried to go to the U.S. Supreme Court. That's what we faced when John Eastman and other Republican lawyers tried to convince courts and convince Donald Trump to disregard the Electoral College results.
So is that the end of it? Because Brett Kavanaugh had an opinion as well where he said that the court is likely to revisit the scope of what state authority has in terms of elections. Are you preparing for something else in the works?
So, look, I really think this is the end of the road, and here's why. You point out this was a 6-3 decision. So the fact that Justice Kavanaugh filed a separate concurrence, he was part of the 6, he filed a separate concurrence, but he was alone in that, right? Which means that there were 5 justices who did not join the, hey, maybe we want to revisit this crowd. The second thing is when you look at the 3, Justice Alito actually didn't opine on anything other than he thought that the case was not properly before the court. Now, I don't put a lot of stock in the idea that Justice Alito would come along with with a strong anti-ISL view, but I think there are 5 justices who have spoken clearly here that they are done with this ridiculous theory, and I think Justice Kavanaugh left open a crack, but not really more than that.
What does it say to you that Chief Justice John Roberts was the one who wrote the majority opinion?
I think that the Chief Justice wanted to put an exclamation point at the end of this. Chief Justice Roberts wrote also the Allen v. Milligan case, which was the Section 2 redistricting case that my firm was involved in winning just last week that created a black majority district in Alabama. He wrote that decision because I think he wanted to put a period and an exclamation point at the attacks on Section 2 of the Voting Rights Act. And I think this was the bookend to that. There are a lot of things that Justice Roberts wants to do that are in my view, are detrimental to the law and society. But I think elections, he wants to tell the court that they're not in that business.
Mark